national level perspective, or even international crimes. I would say different type of crimes, drugs, or even corruption, or terrorism that are in a national level, or that affects many parts of the nation, or even international crimes that not necessarily have been executed or committed in the territory of Spain, but outside, according to different international principles, as what we call personalidad pasiva, which refers on the nationality of the victim, or what we call universal jurisdiction, which not necessarily has a special linkage between the crime, the criminal, the victim, or the object of the crime. And this refers especially to international crimes as genocide, as war crimes, or as crime against humanity, as torture, as disappearances, and also international drug trafficking and terrorism. So this is a little bit the general frame of the legal practice. We have, complementary to that, we have also arbitration, which is not really very developed in our country. It's very little developed in my perspective. There's not much tradition, but there are several institutions, both regional and national level, that are providing arbitration to different commercial and corporate conflicts. And then we have also mediation, both private and public. Private as a private practice, which can be provided by various professionals, I would say, as lawyers, of course, but also psychologists or sociologists or other kind of professionals, depending on the issue and depending on the competence. And just to give you some examples of about that, there is an initiative in Catalonia. We passed a law especially on mediation for Catalonia. We don't have still, that's a project, a national-wide mediation law for the moment. We have like regional laws for the moment. And the government of Catalonia has decided to create what is a public center for mediation that delivers mediation in family conflicts and in other type of conflicts which are mainly private, also organization conflicts, and also provides juvenile mediation as a public mediation project within and in collaboration with the courts specialized in juvenile justice, and this is provided by public mediators that provides this kind of mediation. I'm myself, I'll explain later on some of my experience to give you some examples, but I'm myself, for instance, supervisor of one of the teams of 15 mediators that deliver this kind of mediation to juvenile conflicts and criminal juvenile offenses. How does it work? To give you some frame about that, how does it work in this civil and corporate law, labor, commercial, administrative how does it work? Normally, to be very simple, we have, of course, the figure of the judge, which is not very different of what you have here. But we have different roles and different other people that are intervening in the procedure. And this is what we call procurador, which you might find in a way something really strange, which is a person who was traditionally the expert in adjective law, this is procedure, and who was the person who was in charge, working together with the lawyer, to press forward or try to block, let's say like that, the procedure in the interest of the client, and in a way represents the client before the court. So anything that has to be notified to the client through the lawyer has to be done firstly through this figure of procurator. It's not procurator, its name is procurador, who has nothing to do with the procurator. And at the beginning, this role was compiled and was fulfilled by people who were not necessarily really, have not really studied necessarily all the college of law. Now it's compulsory, so all the people that are doing that job have studied 5 years of college as law studies. And today I have to say that most of the procuradores are basically intermediate between the court and the lawyers. The other role, which is close to your system, of course, is a lawyer, and we can share. I'll try to give you also some personal examples about that. We have to say that in Spain we have about 150,000 lawyers in national-wide perspective, and of course there are a lot who are concentrated in the basic capitals, as Madrid, as Barcelona, as Sevilla, and Bilbao, Santander, and other places. And to give also some concrete perspectives about criminal justice, or some differences that you might find about the practice of law in Spain, you know that mainly there are various systems of criminal law and criminal procedures. You have, if I'm not wrong, basically an accusatory system, and we are based in an inquisitorial system. This means that who was being in the last decades a little bit modified, and in a way there are projects to be modified closer to your system. But historically we had a judge who is inquiring about the crime, who is the leading investigation unit, and there is of course the prosecutor who is there present, but normally it's the initiative, considering that most of the crimes are considered public crimes, is led by that judge, which name is juez de instrucción, instruction judge. This has been lastly a little bit modified, because so it's a mixture of systems, and we have some incursions of accusatory system, but basically this means that today we have these two different judges that are doing different jobs. The instruction judge, which is investigating the case, And we have the deciding judges, which are called Juzgado de lo Penal, or Audiencia Provincial, or Audiencia Nacional, which completely separated from the instruction and the investigation. They just decide what it has been presented as evidences before the court. And of course, the prosecutor is present in both phases of the procedure, and the project they want to do right now is that to switch to your system, so that, as we were sharing in the morning, so that the prosecutor leads the investigation as you have here, but differently to your system, our prosecutor is not eligible. This means that they are functionaries of the state, and these functionaries of the state have done their studies of 5 years of college, and then they apply before the state. Normally it's 2 to 6 year studies and then a special exam, and you become functionary of the state. And we have to say also that the system of the prosecutor at the end is a hierarchical system which belongs and depends on the general, what you have here, similar to general attorney or something like that, the general prosecutor of the state, which is appointed by the government of Spain, which in a way, you have to, if we have to say, and we have to consider in a way, somehow depending, or the independence is somehow questioned about that. So this is a little bit the project, but today, as we were saying, we have these two combined system of two phases, one which is instructional and inquisitorial system, and one deciding system. Of course, we have, as we were saying, the prosecutor as defense of the law. We have then two different roles that you might find also interesting and a little bit different of your system. We have two different roles for the lawyer. We have the defense lawyer, which is more classical and close to your system, which is defending the suspect. And we have also what we call the defense, let's say in that way, it's a defense lawyer, but we call it acusación, which is accusation. We have both private and what we call popular, something like that. This means that these lawyers are defending the interests of the victims, sometimes direct victims, that are the offended people or individuals or groups by the crime, and you become private accusator. This means that you are like a private prosecutor. You can investigate, you can even propose several evidences to be investigated in the first phase of investigation. You can propose that to the judge, and it's the judge that decides, and you are defending these victims directly, and that's why we call that private accusation. And you can also become popular accusation. This means represent either individuals, but mostly organizations that have a direct or indirect interest in the procedure. So at the same time, you can be a private accusation and popular accusation, or that might be different lawyers. And that's why, and that might be different from your system. You would see in our courtrooms that here there's the judge. Normally, I think you have here the jury, if I'm not wrong. Here you will find normally two different tables. Could be different systems, but systematically we could see that. That could be the prosecutor, which is sitting by the private or popular lawyers or accusation, which are in the same side. And as I was saying, in the instruction phase, you can find that the lawyers and the prosecutor ask for the practice of witness or expert or whatever other evidences might be interesting. But during the court, of course, the judge proceeding, but first the prosecutor, but then the lawyer representing the victims or the organizations can do exactly the same. They can also ask for particular evidences, and they can participate directly in the inquiring, in the cross-examination, something like that. We have something similar. It's not exactly cross-examination, but we have something similar to that. And they can participate, and you will find here the defense lawyer.
Can I ask you a question?
Yeah, sure.
Is this scenario where you have both a criminal and a civil action at the same time?
Yeah, that's what I was going to say. This is also a little bit original, and this comes also from a Roman historical experience that allows at the same time to exercise both type of actions. And this is a little bit different from the Roman Germanic system of France, for instance, because in France you have something similar to that, with what it's known as civil party, partie civile, but the civil party cannot present accusation. They can participate somehow in the proceeding, but at the end of the practice of the evidence is only the prosecutor who is going to the concrete accusation. So the lawyer who is representing the victim must shut his mouth and expect that the work that has done is well recognized by the prosecutor. In Spain, we have a more intense participation, because this lawyer or these different lawyers can not only participate in all that, but have different legal consideration about the crime from the prosecutor, and have complete independence on that. And so this is just to show you how a courtroom might be a little bit different of your system. When we have jury also, which has been introduced in the last decades. When we find that, we would find the jury here, the same as you, and in that case, the prosecutor comes here, and the private and the popular accusation come here, so they sit here, and the defense lawyer can sit for the first time with the defendant right here. But with this jury system is the only system and the only procedure that the defendant can sit with his lawyer or her lawyer. In the other procedures, the defendant is right here, completely separated from his or her lawyer. This means that during the oral proceeding, they cannot exchange anything. Everything has to be prepared previously, and so it's a different dynamic. So the jury system, which comes a little bit from your inspiration, also has been introduced in our system, and yeah, most of the lawyers love to watch your American movies about the jury and the dynamic of that, how to learn about that, because you have to be more theatrical than in the normal procedures. Yeah, of course.
Another question. If you have a criminal accusation for which there's also civil liability, are you obligated to bring it at the same time as a criminal trial? And if you do not, are you barred from bringing it later?
It's a good question. You're not obliged to do it. You can focus on the criminal accusation and that proceeding and say, for the civil liability, I prefer to go to another procedure, which of course you have a concrete term to do it. But you can do it both, or you can do it separately, because sometimes you don't have all the evidence you need.
That's the advantage.
Exactly. So you just focus on the criminal responsibility, and then you keep your forces to have more evidences in the civil procedure. We have to say that also there is not only strategical motivation,